It's a privilege to be here and to force you to sit through these mandatory CLEs. See, lawyers have had mandatory CLE for over 25 years, and it does my heart good to know that we've passed that on to non-lawyers as well. Why 4 CLE hours? I have no clue. It was totally arbitrary. Why it doesn't apply to the legislature itself that adopted the law is a really interesting question. And here's another one. Why does it not apply to municipal officials? As part of this presentation, you will see that a significant number of municipal officials have gotten in trouble over the last decade as well. The program is sort of set up in 3 pieces. At the third part, let me start with that, is going to be Pat Gleason. Pat is the go-to expert in Florida on open government, both public records and sunshine law, and you will hear an awful lot of interesting and updated events that have taken place in those 2 areas of the law. Following me will be Carrie Stillman, who is with the Commission on Ethics in Tallahassee. And she is going to cover lots of things that you would, on a daily basis, necessarily need to know about financial disclosure and gift laws and voting conflict and those sorts of more technical issues. When you'll hear that there are 4 definitions in the statutes of relative. They're all different and they all apply differently. And so there's a bunch of things that will be interesting at least to cover there. My job is, as a county attorney, to give you sort of, if you would, a touch on many of those topics, to talk about some things that aren't in Chapter 112, and to, I won't do this because you're veterans, but when I talk to the incoming county commissioners at the new commissioners workshop, my job is to scare them, and I try to do a pretty good job of that. I have a few booking photos in the slides to show you, but not the full complement. Florida leads the nation in the number of our public officials who have gone to prison in the last 10 years. That's not really a wonderful statistic. More than New Jersey, more than New York, more than California. Last, by the way, is Nebraska. Just showing you that nobody wants to do anything in Lincoln, Nebraska. And so that kind of gives you the lay of the land. The other thing I want to preface all of this with is each of you has a county attorney. Some are in-house, some are outside counsel. We like to refer to as outhouse counsel. They're the people that you need to go to about how your county handles some of the things that I'm about to talk about. One of the fun things and important things about home rule is that counties are empowered, whether you're a charter or non-charter county, to have your own rules and do things that fit the way you want to in your jurisdiction. And so what I'm going to tell you generally is the way I do things, and generally it's the way it's done throughout Florida, but it's not necessarily what you might be doing in your particular county. So you need to talk to your county attorney. You need to get your county attorney to be a resource person. They don't need to be your best friend in the world, but by the way, that comes in handy from time to time. You have, and you will hear this from others, not me, when the Sunshine Law was adopted many years ago in the 40s, and since then a couple of cases came out from the Supreme Court, including one involving the Miami Herald, people have misconstrued those cases to be that you have no attorney-client privilege with your county attorney. That's wrong. You don't have attorney-client privilege at your noticed board meetings, except for the ones we'll talk about for the closed door, but you do one-on-one. Now, if you come to talk to me about your divorce, I can't help you and the privilege would not attach. But if you come to talk to me about county-related business, then that's privileged. I won't disclose it without your permission, and they can't make me or you disclose that either. So it's a very important thing to remember that you can come talk to your county attorney in confidence on any topic related to your county commission duties or county business. Like I said, if you want to talk to me about how come your refrigerator was repossessed, that I'm not going to be able to help you much on that. And just to show you how wonderful lawyers and witnesses are, I do a lot of the county's trial work. The University of Minnesota every year compiles a list of silly things that have happened in the courtroom. I guess in January and February there's really not much else to do in Minnesota anyhow. And so here's a couple I just thought I'd share with you before we get started so I can wake you up a little bit from breakfast. The court says, you may call your next witness. The defendant's attorney says, Your Honor, at this time I'd like to swat the opposing counsel on the head with his client's deposition. The court says, you mean read it? He said, no, sir. I mean, I want to swat him on the head with it. Pursuant to Rule 32, I may use the deposition for, quote, any purpose, and that's the purpose I want to use it for. Well, it does say that, the judge says. The court says, then there being no objection, you may proceed. At that point, the defendant's attorney swats the plaintiff's counsel on the head with the deposition. The plaintiff's counsel says, but judge, he says, next witness. The plaintiff's counsel says, I object. He says, sustained, next witness. All right, I'm going to have to cheat with the glasses here from time to time. Court says, is there any reason why you couldn't serve as a juror here today? The potential juror says, I don't want to be away from my job that long. The court says, can't they do without you at work? The potential juror says, yes, but I don't want them to know that. The lawyer says, have you ever heard of Sigmund Freud? Juror says, yes. Attorney says, what have you heard? Juror says, he's in Las Vegas. Court says, I think you're thinking of Siegfried and Roy, aren't you? He said, that's what I'm doing. He said, this guy's a little older than that. Judge says, the defendant says, Judge, I want you to appoint me another lawyer. The court, and why is that? The defendant says, because the public defender isn't interested in my case. The court, addressing the public defender, says, do you have any comment on the defendant's motion? The public defender says, I'm sorry, Your Honor, I wasn't listening. What was the first thing your husband said to you when he woke up that morning, the attorney asked. The witness said, he said, where am I, Cheryl? And the attorney says, and why did that upset you? My name is Kathy. What gear were you in at the moment of impact? Gucci sweats and Reeboks. Can you describe the individual for us? He was about medium height and had a beard. Attorney, was this male or female? Attorney, where was the location of the accident? Approximately milepost 499. And where is milepost 499? Probably between milepost 498 and 500. Question by the attorney. I got like 3 more of these. When you stopped the defendant, were your red and blue lights flashing? Witness, yes. Did the defendant say anything to you when she got out of her car? Yes, sir. Well, what did she say? She said, what disco am I at? Attorney, did you blow your horn or anything? Witness, after the accident? Attorney, no, before the accident. Witness, sure, I played for 10 years. I even went to school for it. Attorney, are you qualified to give a urine sample? Witness, yes, I have been since early childhood. Attorney, what is your date of birth? Witness, July 17. Attorney, what year? Witness, every year. That's it. That's enough of those. I've got a lot more, believe me, we can stretch. And if you all think that the lawyers are in charge, we're not. But the county commissioners as well have, now that you're elected and you've got this mandate from the people, I wanted to let you know one other thing that ought to give you some concern. This is a headline from the Seattle newspaper from November 8th. 2 candidates win majority of votes in Washington state who are deceased. In a Seattle suburb of Des Moines, John Rustiger won 71% of the vote over the other candidates, even though he had been deceased since August. Another candidate won 53% of the votes, and he had been dead since June. So it's not. Voters really, every once in a while, I have some concern about that. All right. Sane advice about crazy topics. This is going to be a potpourri of various things, so bear with me here. Some won't be part of Chapter 112. For example, this issue. Is this part of the ethics code? No, but it is part of what you're going to have to do when land use decision-making gears back up again, which it is starting already. This started in 1993. So we've had 20 years of this new rule in a case that came out of the Florida Supreme Court involving Brevard County. It was a landmark decision, and it changed everything the way we do land use decisions. Again, this is one of those things that you need to check with your county attorney or check with what board policies you may have adopted, because your land use decision-making, except for one thing, from here on out, are quasi-judicial. Does that mean you're a judge? No, but it does mean that you must consider these things in a fashion of a jurist. That is, you must make your decisions based upon information which is provided to you at the open meetings, verbally or in written form. You have to base it upon what is called competent, substantial evidence. That doesn't, so the 500 people are in the audience, they're all against it. 2 people make a presentation, they don't lose 500 to 2. You've got to take a look to see whether or not there's evidence to support or deny a particular application. Initially, the applicant goes first. That changes. Different counties have the staff present first. It doesn't make any difference, but that is something that you're going to need to just be aware of. There's a recent decision out of Gadsden County called Thiele. In this case, the application, it was undisputed that it complied with all of Gadsden County's land use regulations, but residents came to the meeting and opposed it. What happened is that the circuit court found that when the board voted to not approve the application, it had departed from what's called the essential requirements of law and therefore failed to follow this quasi-judicial process. It's a long haul, and you're going to spend money defending these cases that you wouldn't need to. And again, this is a change to the way we used to do things in Florida for as long as I practiced. I was admitted to the bar 35 years ago this month. I've been doing local government ever since. This is an interesting, new in the last 2 decades way of processing things. Here's another case involving the town of Longboat Key. Again, they lost the case because they voted with the public. A $400 million redevelopment, and it was approved by the town but quashed by the circuit court. And the district court said that the circuit court focused on the exact things that they needed to do, and the town of Longboat Key lost this case because they failed to follow the quasi-judicial rules. New topic. No, you can't vote in advance. I get asked that by people all the time. I have 2 of my county commissioners in the audience. It's neither of them. They've never had a silly question whatsoever, and never would. So they're safe. But others have over time say, they come from the corporate world. You can cast your vote in advance. You can vote. You heard earlier at the at the general membership meeting, NACO allows you to vote by proxy for the second vice president, and I hope you do. But we can't let you vote by proxy. And so it's just not a permissible thing. However, with the knowledge and permission of the Attorney General's office, in a fairly recent opinion, they do allow you to vote off premises. We'll get that in a second. So take a look to see what procedures you may have. You do have the ability, provided there is two-way communication. It would be better if it's two-way audio and visual, but if it's just audio, it is permissible for you to participate without violating the Sunshine Law off-site by way of phone. You're going to have to assert some sort of extraordinary circumstances in order to have that happen, and you may have an adopted board rule on that. Our adopted board rule is you need the permission of the commission in advance, so the meeting before. You can't just call in from off-site and say, hey, I got a hangover and I'm not coming to the meeting today, but I want to vote. We also, by the way, in Leon County, do not allow the off-site participant to break a tie. I just have real concerns about that, and as well as with the quasi-judicial issues. So to the extent that there is a tie vote, we move to continue and put it on the next meeting. We've only had that happen maybe, I think, once. But we've had participation from off-site maybe a half a dozen times in the last 10 years. All right. You'll hear from Pat Gleason this afternoon about the Sunshine Law. It is the most broad-based, liberally construed open government law in the country, by far. People in California, who you would presume have the most liberal rules on this, are astounded about Florida's rules on Sunshine Law applicability, and we'll talk about a couple of cases. The problem with Sunshine Law, and I'm not going to hit on all of the applicable stuff because that's what Pat is going to do, but let me tell you, there are two consequences that you need to be aware of, both from you ethically and from you long-term reputation. One of which is, if you violate the Sunshine Law anywhere along the string, and I don't mean you, I mean somebody in your county. There's a famous case called Gradison out of Palm Beach Gardens, and there's another one out of the town of Palm Beach. Why they were test cases, I'm not sure, in which the violation occurred at a subcommittee meeting of the Planning Commission. But because that took place, it tainted the entirety of the whole process. And so it went to the full Planning Commission, it went to the commission itself and was all approved. Then they were sued, and the court said, if there is a Sunshine Law, it reverts back to whenever the violation took place, and it makes it, here's your Latin phrase for the day, and I won't say too many of them, it makes it void ab initio. What does that mean? It's as if it never happened. That's a bad thing, because in addition to being embarrassed, you will also probably be sued by the applicant over some sort of delay. The other thing that can happen to you is that you can be charged personally with a violation of 286.011, and it carries with it both civil and criminal penalties. You can be fined. Most of the time, the violations have resulted in a civil fine of up to $500, but there are criminal penalties of 60 days in jail. I don't know if you were at the presentation yesterday on public safety, but jail is not a really fun place. And we'll talk about federal prison here in a minute, which is even less of a fun place. This occasion here out of Lake Wales is one of my favorite Sunshine Law violations currently. It has three component parts that were wrong. All right, one, you may not discuss substantive matters outside of a publicly noticed meeting. That's what these commissioners did when they went to the restroom, okay? Two, it was overheard by a reporter. Rule 2, there is nothing off the record with reporters. Don't ever be sucked into that. I have advised my commission to never let them be recorded either. You're not obligated to let the newspaper reporter put a portable tape machine on the desk. Don't do it. It's a bad idea. Have you ever seen Photoshop photos? Same thing with audio. Don't let them do it. And finally, the third rule which was violated here, and which one learns as a young boy early on, there's no talking in the men's room. Okay, that's the third violation that happened in this. So, sunshine, off the record, talking in the men's room, bad idea. That's a triple header. Yes, ma'am.
Yes, what about the newest phase where people are texting one another on their own private phones, and you can't ever, take a look at those messages. Nobody knows how to request them.
The question was, what about texting? We're going to talk about that in just a second. So anyhow, surprisingly, the Lake Wales guys were found to have violated the Sunshine Law. This is another interesting case involving also Lake Wales, the Housing Authority. This guy was just unashamed of the whole idea. He said, listen, this is going to be a tough item to resolve. Why don't you all just go out and join me in the hallway and we can chat about it, okay? And they did. That's the part that, the fact that there was one person with a bad idea, then he sucked two more people into joining him in the hallway. They were fined $67 and ordered to pay $500 in court costs, by the way, each. My favorite booking photo. You all may remember W.D. Childers. His entire personal empire came tumbling to the ground during this time period. He was convicted both of Sunshine Law violations and of bribery. You may recall, those of you who are new may not, but he was accused of taking a bribe, and the person who was a part of that, a guy named Willie Jr., was also involved. Let me tell you first about the Sunshine Law case. The Sunshine Law case, great article from the Pensacola newspaper, which I keep in my desk. The sentencing judge, after he found him guilty of the Sunshine Law violation, said, Mr. Childers, I am going to sentence you to the maximum possible fine and time in prison because you failed to follow the advice of your county attorney. So just keep that in mind, that could be a factor in this. The other part about the bribery conviction, by the way, he appealed that on the basis that he was denied his constitutional right to face his accuser, which was Willie Jr., who had died under unusual circumstances, shall we say, prior to that time. At one time, the court overturned it, but in a rehearing, what they call en banc, which is the entirety of the appellate court, they reinstated the conviction. He is now out, by the way, having served the last 3 years of his sentence, helping pick vegetables at the Belglade work camp. We'll talk a little more about honest services, but in this case, he's a convicted felon. Guess what? He lost everything. His entire FRS pension, everything. So jail ain't fun, but when you get out and you're penniless too, it's a lot less fun. All right, the one exemption, there's actually two exemptions to the Sunshine Law. You got to be very, very careful about these though. The one exemption is if you have There's really technically three. One is if you talk about security plans, but you tend not to agenda those things. The second one is if you have a collective bargaining union, in your county, and you are formulating the position you're going to take for upcoming collective bargaining, you are allowed to meet with your lawyer and your manager in a closed-door session. And by the way, all the paperwork that is generated for that is exempt from public records disclosure during that time period, too. And then the third one, which took a long time to get into the statutes, it's not been around very long, maybe about 15 years, is 286.011 subsection 8. That's what is sometimes called the closed-door session, sometimes called a shade session, sometimes called, accurately, an attorney-client privileged meeting. The deal here with these, though, that you need to be careful about is they can only be called for pending litigation. And litigation is not a claim. Litigation is not the threat of a lawsuit. And there have been a lot of mistakes made during the course of covering these things. The county attorneys and the city attorneys have for a number of years tried to push through an amendment to allow this to be expanded. If you get a claim, a personal injury claim, and you get the notice under the sovereign immunity statute, isn't that really the time where you should have a closed-door meeting to figure out whether you should settle or not? Not after you get sued, because the price has already gone up significantly. But the legislature has not agreed to do that. So it's only for pending litigation, which, by the way, includes appeals. There are strict rules about how this has to work. You have to open a meeting publicly. It's silly. Then you throw everybody out of the room. Then you have to discuss the matter with a court reporter present. The court reporter has to transcribe the proceedings, but it's exempt from public disclosure till the case is over. And at the end, you have to resume your meeting publicly and announce that the meeting is concluded. During that time, you have to announce who's present and a lot of other things. This is an AGO from this year talking about they could not hold a closed-door session on arbitration. So it's litigation, not arbitration. It's very strictly construed. And this is the city of Vernon. They made the mistake. Remember I said open it publicly, close the meeting, reopen it publicly. They forgot to do the reopen it publicly at the end. Therefore, the court found that they had violated the Sunshine Law, ordered them to pay court costs, and you know what else these courts have done as a penalty. It happened with Duval County School Board, it happened here in the city of Vernon case, and it has happened a number of other occasions. And that is, the court deems your Sunshine Law violation to also have waived the exemption for your public record. Therefore, the court reporter's transcript of what you talked about becomes public. Guess who makes the first request? The plaintiff. Guess what happens next? You settle very quickly for a lot more than what you would have settled otherwise. So be very cautious. Yes, sir.
Yes, you mentioned it has to be pending litigation. What about union negotiations? I know you mentioned collective bargaining, but it's not litigation, it's a strategy for union negotiations.
The exception for strategies on union negotiations is exempt also. It's just under a different section. That's in Chapter 447 of the statutes. All right. Pat will talk to you a little bit more about conflict of interest. My point in talking to you about it is there are a couple of people around, probably in this room, who have been confused about the conflict of interest issues, and here's the two issues that come up. There are two rules about participating in the discussions if you have a conflict of interest. In Florida, the rule has always been that you must vote on every topic. You're not allowed to have a call of nature when you're about to vote on something and therefore intentionally absent yourself from the meeting. So you must vote on everything, unless you actually are absent, you're ill or whatever, unless you have a conflict of interest. But because I have a conflict of interest, I'm not allowed to participate in the discussion. That's wrong. Appointed boards are prohibited from having the discussion on matters where that individual has a conflict. Elected officials are not. You can talk about stuff even if you have a conflict of interest. It's a kind of an odd distinction, but you're allowed to advocate for something that you can't vote on. And it's just, there's a lot of odd stuff in Chapter 112. Yes? I'm sorry, say that again? All right. The question was, what about conflict in employment? Let me recommend that you ask that question of Carrie, who comes up next. My quick answer to that is you can't work for the entity where you're the commissioner. This gentleman here in Bunnell, he settled with the Commission on Ethics. He was a commissioner, and he voted to retain his own towing company as the towing business for the city. That one, to me, you should have been able to figure out, but you know, people sometimes get all excited about the moment. Chapter 111. Is there a question? Yes, sir. The question is, does that apply to if you are a member of some not-for-profit organization? The general answer to that, in my opinion, is you do not have a conflict of interest if you are voting to, say, give money to the United Way and you're on the board of directors of the United Way and it is a volunteer, non-compensated position. There are some exceptions to that, like your spouse is the executive director and she will get a pay raise. You know, there's a little more complex to that, but just because you're a member of the hospital board or the Boys and Girls Club or the YMCA or any of those sorts of things, and they're getting money or getting a contract or something like that, the answer is no, because it does not. Here's the key phrase you'll hear Carrie talk about: it does not inure to your special benefit or your spouse. Yes, sir. You did the right thing. The question was, if you didn't hear, he had a business where the county purchased hydraulic equipment from his business. When he got elected, they ceased that. That was a good thing. There are emergency exceptions to that, and Carrie's going to talk about them. I don't want to steal her show, but there are some exceptions. Sole source is one of them. Yes, ma'am.
I just wanted to make the distinction in Broward items.
The Broward Ethics Code makes it even more severe, was what the statement was, that they're not allowed to participate. That is more restrictive than the state statute, and that's why you're allowed to do that. You can't go the other direction. All right. Another thing to find out if you're a newer commissioner, and if not, my recommendation to you is to get your county to adopt a policy in advance, and that policy deals with reimbursement of your officials, mostly you. If you are charged with an ethics violation or you are charged with a crime, you are entitled, as a matter of Florida common law and under Chapter 111, to be made whole. Some counties do this differently. Some counties will provide you a lawyer up to the point of the Ethics Commission finding probable cause to believe you violated. Then you're on your own. other counties, Leon, tells you that you must get your own lawyer. I highly recommend getting a lawyer, by the way. I have seen a lot of people do this on their own. It usually works out badly for them. And there are a number of lawyers who do this sort of thing all the time. But get a policy established in advance. One of the things that policy ought to include is how much you're going to pay. I don't know if you remember Barry Richards, a lawyer in Tallahassee, represented one of the presidential candidates, and I don't even remember which one anymore in the big dangling Chad issues. He charges $900 an hour, okay? You can hire him if you want. We're not paying you $900 an hour. We set our rate based upon the going rate in the community, and currently it's $225 an hour. That's all we will reimburse you. Why did we do that? Because we had these two cases that took place in Leon County in the early 2000s involving a commissioner. Those of you who have been around a long time probably remember Rudy Malloy. He was a commissioner, chairman of our commission, and president of this organization some years ago. He was accused by his aide of sexual harassment. For reasons I'm not really sure, the governor got FDLE to investigate that. Sexual harassment, while is a horrible thing, is not a crime. But somehow the governor ordered FDLE to investigate. While they were investigating that, they also discovered receipts which would indicate that the commissioner had triple dipped on travel reimbursements. He worked for FDOT at the time. He was president of this organization and a county commissioner, and there were certain receipts which appeared to have been submitted to all three organizations for reimbursement for the same event. That issue went to trial. Those are misdemeanors, 4 misdemeanors. We would have paid a conflict lawyer, back when we paid conflict lawyers, $200 per case, so a total of $800. Mr. Malloy's lawyer racked up a bill of $337,000. In addition to that, he was taken to the Commission on Ethics on the sexual harassment issue. They accused him of misuse of office, and you'll like this, and I thought I saw Carrie step in the door there a minute, but they also charged him with a violation of taking additional compensation on the basis that sex has value. If you've not met my wife, you might dispute that. But anyhow, she would say the same about me. Okay, that's, anyhow, so we had 2 cases that arose, one civil, one criminal. Mr. Malloy won both of those cases. A jury returned a not guilty verdict on the criminal case, and the Ethics Commission found him not to have violated Chapter 112. He then sought reimbursement from the Board of County Commissioners, and under the rules established, there's a case involving John Lamello. Again, you veterans may remember him as the mayor of Sunrise. That case stands for the proposition that if you win your criminal case, you get reimbursement. The Board of County Commissioners did not agree to reimburse him for either of those things. That was appealed to the First District Court of Appeal, and the First District Court of Appeal said 2 things. One, for a criminal case where you're found not guilty, even if everybody thinks you are guilty, you're entitled to reimbursement under the Lamello case. 2, because you didn't set a cap, you have to pay them the entire $300 and some odd thousand. Item 2, on the civil, the ethics case, the court allowed us to apply what is called the 2-part test that comes out of the city of Fort Walton. The 2-part test is, 1, was this done in the course and scope of your duties as an official? And the answer is yes, he used his office for purposes of having an affair with his aide, oh, by the way, and another commissioner's aide and another aide. And one he fired for not doing so. I'm not making that up, that's the testimony in the record. But under this test, which is called the Thornburg test, the county commission is allowed to make an independent determination of the facts. And our county commission, based on my advice, concluded that A, it had occurred in the course and scope of his job function, but two, sex doesn't serve a public purpose. So it failed on the second part of the two-part Thornburg test. Yes, yes, I am. That's what we determined, and the First District Court of Appeal agreed with us that sex doesn't serve a public purpose. I'm not sure that's a really solid rule, but for purposes of the attorney's fee reimbursement, I had another idea, but I tried to steer away from it. Yes, sir.
In the case involving the sex and compensation, did the court require expert witness?
That we hired Commissioner Deloge for that.
What did he charge?
That's that's no, that's no. Everybody's got to have a trade, you know. That's all right. Electronic communications. Back to your issue.
What about just merely in defense of someone, where you never get charged, but it's just defense?
It's a mixed bag on that right now, but my position is if you have to hire a lawyer and the lawyer is able to convince the Ethics Commission that there's no probable cause to charge you with a violation, that likewise qualifies for reimbursement. Or the state attorney's office. Let's assume a grand jury presentment finds you they arrest you based on that. But ultimately, the state attorney drops the charges or doesn't proceed, I think you're entitled to reimbursement for that if it occurred as part of your commissioner duties. All right, two things about electronic communications. Don't do them. There. That's what I've told my commission. They've ignored me, but that's okay. I feel better telling them not to do that than them saying, Herb, why didn't you tell me not to do that? The electronic communications has three huge problems that you need to be aware of. One, if you text somebody and that text is about county business, that text is a public record. You're now the records custodian, and you have to preserve that somehow. Good luck. Some phones you can do screenshots, some phones you can email yourself, but it's a very, very difficult thing to do. We have turned texting off on all of our county-issued phones just because it's such a pain in the neck to deal with that. Two, if you text or tweet or Facebook another commissioner about a subject that you're going to be considering, in addition to creating a public record, you've also created a public record that will prove you violated the Sunshine Law. That is a potential problem. There's an exception. If you text somebody and they don't respond, that's not a violation. You send a commissioner a memo, they don't respond, that's not a violation. But the problem is we have a tendency to provoke, if you would, a response. This is the most ridiculous thing I've ever seen before, and I'm not voting for your silly project. That person is going to feel compelled to respond to that, and that creates the violation. And finally, the third problem is these blogging sites. And I have already seen one case, I won't tell you where because nobody's been charged yet, where people used pseudonyms. You know, I'm Sunshine Girl. Well, that's really Commissioner Smith, you know, and I'm Doughboy, and that's really Commissioner Jones. And they're on this blog site debating an issue that's before the county commission, when it is found out ultimately that that's really not Mark Twain, but it's Samuel Clemens, the county commissioner, then that's going to be a problem for them. Yes, ma'am.
Does it, what if they don't know?
That is a good, I'd like that as a defense. So the question was, what if they don't know that each of them is using that? I think that might represent a defense. But I'd rather my commissioners not have to raise that as a defense. One of the worst things for you publicly is it's on the front page of the local paper. Doug?
So is it any different than if the press calls you on a Friday and asks you how you're going to vote on Tuesday, and there's more than one commissioner responding in the paper as to how they're going to vote?
I think that is not a sunshine law violation. If the reporter says, hey, I just talked to Commissioner X, Commissioner X says he's supporting that, what are you going to do? And they do that a lot. They're actually a conduit, a sunshine law conduit. I think they violated the sunshine law, but I don't think you did. Right, and why get yourself in a pickle? So, yes, sir.
Regarding the text or any of that type of thing, like personal phone,
Makes no difference, personal phone. This is the problem they had, by the way, in Orange County, which you probably have all read about, which during the course of a debate over putting a matter up for referendum, there were lobbyists texting back and forth, and they ultimately now have resolved this matter by agreeing that they should just pay a civil fine, but it just represents one of the problems. All right, honest services. Let me move. Your driver's license photo sucks, okay? It is no glamour shot by any means. Your booking photo, however, takes the cake. They're never going to be a good thing. There's a case that came out in the last 5 years involving Skilling. Do you know who Skilling is? Skilling is the guy that faked the books in Enron, causing Enron to go down the tubes. He was charged with a lot of things, including SEC violations and violations of the Honest Services Act. The Honest Services Act is a creature of the 1920s when people were selling swampland in Florida. All it involves is a communication and an argument that you've deprived the people who were relying upon you of their honest services. That's how it started here with the U.S. Attorney's Office and the FBI. Really, the first visible cases in Florida were the commissioners in Palm Beach County. At one point, the Palm Beach County Commission had a quorum in federal prison. That's really not a good thing. Okay, that really doesn't make me feel a lot better, actually. If you, yeah, well, he could participate by phone on the one phone call. If you want to hear details about this, let me know, because I'm trying to push along here so I don't eat into Carrie's time. But the Skilling case came out, and everybody presumed that the U.S. went to the U.S. Supreme Court, and everybody presumed that that would be the death knell of the use of honest services. I mean, Palm Beach County, Broward County School Board, a pile of officials all throughout the state. And the deal, by the way, just so you know, with honest services is the federal statute says For every count of a violation, it's 20 years in federal prison. You get charged with 15 or 16 or 20 counts of honest services fraud, you're going to die in prison. That's how the FBI negotiated all of these 5-year settlements. They said, do you like to die in prison, or would you like to serve 5 years? Well, that's a heck of a negotiating posture to be in, and so most people took the plea deals. The other problem, by the way, with the plea deals, though, is you forfeit everything. If they can have even a thread, a remote connect between your personal possessions and what you did, they forfeit everything. Mr. Mazzalotti, by the way, even his wife had to return the funds she got in their divorce decree because of that. They lost, Mary McCarty and her husband Kevin lost their home in New England, their home in Palm Beach County. Oh, and by the way, your FRS is done. It's toast. Every pension you have, all of the things you put away, all of your deferred comp is gone. It's not a good thing. So the Skilling case, it says this is a constitutional provision in the federal statutes, provided it is applied to bribery or kickbacks. So while Mr. Skilling did not get a bribe or a kickback and was therefore found to not have violated the Honest Services Act, the court upheld this. And so it is still being used around Florida by the FBI. Don't be convinced by folks that says, that's done now, because it's not. For example, in August, a couple of mayors were charged with bribery and kickback. The mayor of Sweetwater, I'm told, by the way, he took a plea deal this week on that. The Sweetwater issue is he was offered money to help somebody who get a grant. And again, I wasn't present, but I was told that the FBI had this person wired. And when he agreed to do that for money, the FBI agent then said, by the way, do you know any other mayors who'd be willing to take money to do the same thing? He said, of course, I'm the president of the Florida League of Cities. I know all the mayors. And 2 or 3 more went down as a result of that. You remember the mayor of Detroit. Well, just last month, Honest Services was used to put him in federal prison for 28 years, all right? Plus, he had to give back all of the other monies he had received. They even convicted his father of being a participant in that. Honest Services is alive and well in the United States. Be cautious of that. It's a heavy duty. Yeah, bribery is a violation of Florida statutes too, but the state, pardon me, the state attorney's office have deferred to the feds because the penalties are so severe that they are able to get not go to trial. They are able to do settlements. A quick one on Honest Services. One of my peers was convicted of Honest Services, and I won't, well, okay, Jimi Hendrix, not the guitar player, but the county attorney. After his sentencing, he appealed his sentence, which was probation, to the 11th Circuit Court of Appeal, because remember, it's a federal case. That was a bad idea, because the 11th Circuit Court of Appeal reversed and remanded on the basis that the penalty was not sufficient, and the trial court was ordered to increase the penalty for the violation. It's really wire fraud, but if you see it's in your materials, the statutory phrase is to deprive somebody of their right to honest services, which is a fair shake, your honest treatment of them. That's Mr. Skilling. By the way, his appeal failed. He's now only serving 14 years in prison. The question was, how do you get caught up in that? The answer is, usually, it has come up in, this is a shock, land use cases, probably primarily in a lot of procurement cases. And that is either an elected official requests, if you would, that's called extortion, but requests that they be compensated for their vote, or the applicant says, listen, I'd be willing to make a large contribution to you, your favorite charity, which is, by the way, also you, if you would vote for my particular, or buy my product. Usually, the competitor or the opponent is the one who turns them in. It's generally not, if you're trying to squeeze somebody, it's them, but most of these have come from other people who didn't get the contract. And so they go in and they usually wire. There's a really embarrassing video of the school board person from Broward County. Not only did they have a person wired, but they have video. He had a camera tie. Went in and delivered the bribe in a brown paper bag, just like you see in the movies. She put the brown paper bag in her desk drawer. As soon as she shut the doors burst open. The FBI came in, put her in handcuffs, and walked her the entirety of the school board offices out to the waiting car. And so that's how they come up. Yes, sir. Oh, it can apply to anybody. I didn't put on this slide because this is not the scariest slide, although I seem to have had that effect. A pile of public works officials and engineering officials from cities, both sides of Florida, Palm Beach County and Sarasota, were also arrested for honest services fraud for steering contracts to particular engineering firms. So it applies to me. It applies to appointed officials. It applies to your employees. Yes, sir.
The person is found guilty of doing this. What happens to the person that made the bribe originally? Are they liable for this at all?
Generally, the question is, what about the guy who did the bribe? Generally, the answer has been they've cut a deal with that person for his testimony against the elected official. They won't pursue charges. That's generally what has happened. This is why you're here, the ethics reform stuff that passed last year. I'm not going to go into that. I'm sure Kerry will probably cover most of that, and I have more or less run out of time. There is a recent CEO, that's a Commission on Ethics opinion, that talks about how this is all to be implemented. I wanted to get to the last thing, which is a cautionary note. Every person and every commission in Florida also has this. Do you remember the Andy Griffith Show? Every local county commission has a resident nut who comes to the commission meetings with some frequency. Now, I believe that the large structure that some people think is the legislative office building in Florida between the two domes is offices. I believe it's a gigantic kook magnet. Ethics, this has everything to do with self-survival. Don't engage them. Thank them for their presentation or time, and provided that they haven't gotten crazier than they were when they arrived, and don't threaten you physically. And under this new, by the way, Senate Bill 50, and that's the tie-in actually here, about the public's right to be heard, it does not say the public has the right to be absurd. You still can maintain decorum in your commission meetings, and when Tom Terrific comes in the aluminum foil, we had a guy who made space sounds who said that we were beaming stuff through him from our public safety complex, and those sorts of things. You may usher them out without violating Senate Bill 50. So I think that's the end of my, yeah. There he is, Howie Morris, by the way. He wrote himself into the show from time to time. He was the producer or director of the show. That's it. Questions about anything? I'll be around a little while, but let me know.